Now let's get to Parliament. Not Parliament per se, but let's speak to our parliamentary correspondent.
Kweku. It's an extension of Parliament.
It's an extension of Parliament. Kweku Asante, good morning.
Good morning, Winston.
So tell us, Kweku, what transpired? I mean, tell us what transpired in Parliament yesterday. Give us the backstory of everything that happened yesterday.
Winston, just around 1 p.m. yesterday, the Minority Leader Dafeamekpor addressed journalists, and he did so in the company of his other colleagues, together with Nyindam. And the substance or the pith of their argument was that the judge in this matter did not do substantial justice. In fact, Dafeamekpor talked about a lot of things, but three themes stood out. I mean, first, he accused the judiciary of doing the bidding of some unknown or faceless paymasters, and that the conduct of the judiciary in some of these matters have been shameful and disgraceful, and that they were not afraid to be very critical of the courts, and that if the judiciary were minded to cite them for contempt and even convict them and put them in Sawam, they are willing to go there and spend the days there. He talked about that. He then claimed that it would appear on the day the judgment was read that the NDC knew about the judgment even before they came, because of the way they came to court with certain dignitaries and other people and all of that. And then ultimately that they do not consider that this matter is over. They are going to challenge it to the very logical conclusion, and that Nyindam remained the member of parliament. So they did a news conference that lasted almost an hour. Dafeamekpor spoke for 45 minutes or so. And then they went back into the chamber. So Nyindam in his blue suit, red tie, blue shirt, he then went to take his seat. He sat there for almost an hour. There was no challenge. There was nobody raising an issue. He sat there. He kept going in and out. Then he decided that he was going to debate. In fact, both sides had sent a list of who was debating. You know, Parliament has been debating the 2026 budget.
Yeah.
So the second deputy speaker was presiding and mentioned the name. NDC MP had just debated. And so he will mention the name of the next person who is about to debate. He mentioned the name of Nyindam, and then the chamber just erupted. Like, oh, really? So, Roxy Nelson Dafeamekpor, the member of parliament for South Dai, and the majority chief whip was on his feet. He was with his rules book and his constitution, trying to quote some precedents and all of that. So the speaker gave him an opportunity and said there was no way they in the NDC were going to allow Nyindam to contribute. And then as far as they are concerned, he is not even a member of parliament to even enter the chamber of parliament, let alone debate or ask to speak as a member of parliament. Because as far as they are concerned, a high court in Tamale has annulled the election that brought him to parliament. And so Nyindam is not an MP. They are aware that Nyindam has filed a notice of appeal and has applied to stay the judgment of the high court. But in their view, a notice of appeal does not act as an appeal. And a notice, or actually filing a stay of execution, does not act as a stay of execution. He went on to decide a plethora of cases that the Supreme Court has decided and all of that. And so he also went on his feet, he spoke, and then he started the issue of Dachekwe and how the NPP blocked him from accessing the chamber and all of that. And then Dafeamekpor also came in and responded. And then he challenged the substance of the points that had been made by Roxy Nelson Dafeamekpor, and that he elected because when Dafeamekpor was speaking, he used words like "it will not happen," as in Nyindam will not be allowed to speak on the floor. So Dafeamekpor spends quite some time on that and says that it appears that the majority want to use physicality instead of using the arguments of law and all of that.
Okay.
And so the member of parliament should be allowed to debate. So when it was about to wrap up, and whilst all of that was going on, you see the second deputy speaker, Andrew Amakwesiama, who was sitting in the chair, he was making notes as though he wanted to make a ruling, because ultimately the majority had invited him to make a ruling on this matter. But I saw a gentleman just briskly walk up to the second deputy speaker on the speaker's days, whisper something in his ears. And then as soon as the majority leader finished speaking and the invitation is extended to the second deputy speaker to make a ruling, he tells us that the Speaker of Parliament, Alban Bagman, who had not been in the chamber throughout yesterday, had given indication that everything regarding whether or not Nyindam continued to be a member of Parliament should be put on ice. and that he, Alban Bagman, want to be the one to make that determination as to whether or not Martin Nyindam is still a member of parliament.
Now, Kweku, kindly hold on for me. Kweku, kindly hold on for me, because we've been joined by a member of parliament for South Tai and majority chief whip in parliament, Roxanne Nelson Eche Dafeamekpor, is on the phone. Honorable Dafeamekpor, good morning and thank you very much for joining us.
Good morning, and I'm glad to have joined you. Good morning to your listeners.
Great.
And your viewers.
Good. So help us understand. I mean, your colleague has, yes, the Tamale High Court has annulled his election, ordered a rerun in 30 days. He's appealed and has also applied for a stay of execution pending the determination of the appeal. So why didn't you want him to debate in Parliament?
Now, the law has long been settled that he is no longer an MP. There's no substantive court order staying the order of the court directing that the election, the result of which is the product that brought him to Parliament, should be rerun. No order is, as we speak, has been given to vary or stay the execution of that. Number two, it's also tried that filing a notice of appeal, which can be discontinued tomorrow, does not operate to stay execution of a court order. Three, again, the law is tried. So many plethora of cases, Ghana Hotels Association versus a PIC Plus, Supreme Court decision 2012. Filing a stay of an application for stay does not operate as a stay order substantively given by the court. So that's the principle of law. So to seek to say that because he has filed a process to, one, appeal the decision of the court, and two, to stay the execution of the court order, should permit him to return to Parliament and have a voice and have a standing on the floor of the House, is totally unlawful and unconstitutional. Now, the point is further made that because the stay is pending, so he must be given a voice. But they did the same thing to Jachi Kwesi, my brother Jachi Kwesi, the Deputy Foreign Affairs Minister. I argue at the time that the filing of the stay should bring him some reprieve, temporary reprieve as it is, and should have a standing. They said no. They said my argument was flawed. Even the Jachi Kwesi matter, it wasn't a substantive court order upon the final determination of the case on its merit. It was an injunctive order, if you recall.
Mm-hmm.
The Supreme Court said that Jachi Kwesi should desist from holding himself out as an MP until the final determination of the case before it. So tell me, who suffered the greater havoc or damage in similar circumstances? Jachi Kwesi was an interim order from the court. They proceeded to prevent him from having a locus on the floor.
So let's stay with your argument at the time.
And they actually prevented him from having access to his office in Parliament.
Okay.
His common fund was stopped. It wasn't paid to him to do anything.
Okay.
Why do these guys think that they are the wisest people in this country?
Now, Roxanne, let's get back to your argument at the time. Now, tell us the basis of your argument when at the time you believed that the application for a stay of execution gave him some bit of a room to operate till the determination of the case.
Now, I believe that when you file a stay, being a court process, it should be respected. But do you know the counter argument, which was more forceful and was persuasive? They say yes, but he who comes to equity must come with clean hands. Why? When there's a substituting court order substantively issued from a court, you need to respect that first. So you don't stomp to the chamber and say that my process, the effect of my process should be respected, but the effect of the court order, which you were seeking to have stayed, should not be respected. You see the irony?
Mm-hmm.
That if there's a court order that says that you are no longer a member of parliament, respect that first. Agree. Let's respect that first. So don't storm the chamber and pretend that you can present yourself as a member of parliament.
But
so
you
if the
believed
equities are equal.
Yes, but you believed at the time that your argument still was valid, right?
Yes, my argument was persuasive, but the more persuasive one was that no, the substantive order of the court ought to be respected first and foremost. So you don't disregard that and come to the chamber and say that because you have filed a stay, the effect of that stay should be respected. So if the equities are equal, the first in time will prevail. So the first equity in this case is the order of the court that must be respected. So once the court says the election is flawed, you have to go through a rerun. That is what you submit yourself to first. You don't disregard it.
Has Parliament been informed of this ruling?
Yes, Parliament was served 3 days ago. The Electoral Commission has also been served. And we are picking up intelligence that the Electoral Commission is hesitant. We want to serve notice. We will not tolerate this any further because the Supreme Court has been very clear that even an injunctive order, a prayer for an injunctive order cannot operate to prevent the constitutional body from performing its constitutional functions. This was the authority in Dafeamekpor versus Attorney General. When I sought to injunct the president, injunct Parliament from vetting ministers who I thought that were irregularly nominated for ministerial role, the Supreme Court said no way. The filing of an injunction cannot stay, and you can also not bring an injunction to prevent a constitutional body from performing its functions. So there's no order preventing the Electoral Commission from issuing the rerun notice. And let me juxtapose this against the Jachikwesin case. When the Supreme Court issued the rerun order, the order came late morning. By mid-afternoon, the Electoral Commission had issued the rerun order for Asinoff. If you recall, nearly everybody who mattered in NDC, we had to stop everything we're doing to stop Asinoff. So what is preventing the Electoral Commission since the issue of the order from the High Court Tamale directed at the Electoral Commission to order a rerun of the election and issue a notice within 30 days?
Yeah, but it's within 30 days. So, I mean,
no, the rerun must be done within
exactly.
30 days.
So the Electoral Commission can do that.
We have already lost 3 days. We have already lost that 3 days of that 30 days. And to order a rerun for an election, you need to give adequate notice. You need to file. You need to invite nominations for candidates to file. We've already lost 3 days. So the conduct of the Electoral Commission in this matter is of great concern to the NDC.
Their conduct is of great concern to you. You think that
yes,
the
tacit reluctance.
You think that
the notice in compliance with the court order is of great concern to us.
You think that their reluctance, your perceived reluctance on their part is deliberate?
It's deliberate. Because if you juxtapose this to their previous conduct in similar circumstances, it's shocking. It's revealing the alacrity with which they move to issue notices in previous circumstances that had the NDC. They are not demonstrating the same alacrity and speed.
Are you suggesting that the Electoral Commission was in a hurry to do, in the case of Jachikwesin, something that could hurt the NDC? And now, in having to take a similar decision that you believe could hurt the NPP, they are not doing so, and thus the Electoral Commission is favoring the NPP?
Of course. That's a reasonable conclusion to draw, given the circumstances that we find ourselves in. Because you see, in this matter, they are a party. So they were in court. So in a more reasonable sense, they even need not be served with the court order because the court order was issuing from directed at them, directly in court. But we took precaution to have the order drawn out, remitted to the High Court in Accra and got the bailiff of the High Court in Accra, Solomon Safo, to serve them. And I have proof of service. Both Electoral Commission.
All right, Roxanne. So finally, for you, you've heard Matthew Nyindam this morning. No, yesterday he says that he respects the ruling of the court. He's a law-abiding citizen. And so that's it. While we wait for the speaker's ruling, what if the speaker says he can continue his work?
I doubt, because there's precedent to guide speaker.
If the speaker says he can, what would you do?
That would be a departure from existing precedents.
And so what would you do?
We have procedure under law, under parliamentary procedure, to challenge that decision.
You're prepared to challenge the speaker if he departs from what you...
If a decision, because where I sit as the majority chief whip of the government in power, of the party in government, if my candidate who suffered for 10 months, who had been deprived of the opportunity to represent his people in Kpandai, remember that we were the sitting MP.
Yes.
It was a candidate who was a sitting MP, who was deprived of the opportunity to return to Parliament. Quietly will suffer for 10 months. And so if there's an opportunity for things to be corrected, why should we be deprived any further?
Well, the correction is subject to an election, Roxanne.
Exactly.
So it's not a done deal, is it?
Let's not subject ourselves to that. We must not give the person who the court, as we speak, the court has declared a persona non grata. He has no locus to be in Parliament. The process that brought him has been declared as by judicial pronouncement as flawed, as irregular. So the regular thing must be done. He cannot continue to sit in Parliament.
Roxanne,
to benefit from what has been wrongly declared by the court.
Roxanne Nelson Dafeamekpor, thank you very much for joining us this morning.
It's my pleasure.
Roxanne Nelson Dafeamekpor is Member of Parliament for South Danyi and also the Majority Chief Whip. Let's just stay with Kweku Asante and find out what would happen in Parliament today before we wrap it all up on discussions in Parliament. Kweku, so what's the plan for Parliament today?
Well, the expectation ultimately will be that the Speaker of Parliament, having given indication that he intends to make a decision on this matter, will do so today, because it's a very important constitutional matter. So if Alban Baldwin takes the seat today, at any point today, one of the things he'll be expected to decide or make a determination on will be this matter. But ultimately, the two leaders, Alexander Fejo-Markin, Mahama Yarga, are expected to wrap up the debate on the 2026 budget. They will debate an hour each from 12 o'clock. And then when they are done, the budget will conclude. Then the various committees, the ministries, first of all, will have to now come and lay the estimates for their ministries, the budget for their ministries and departments. Then the various committees start working on it up until almost the end of December, when Parliament will go on break for Christmas, so that these budgetary allocations will be approved. And then ultimately an appropriation act will be passed on these matters.
So in effect, the expectation is that today the economic policy of government could be approved.
Yes, when the debate concludes, it would have ordinarily been put to a vote, but because the minister came by way of statement, what they've been doing is commenting on it, and he didn't come by motion, and so there will not be a vote. That has been some of the departure and some of the things the minority have been talking about. In fact, there is currently a motion on the other paper in the name of Alhaji Habib Idrisu, asking the speaker to make a determination on whether or not the budget must come by way of motion or statement. We will recall that in 2022 or so, Ken Ofori-Atta came by way of motion, presented a budget, and the budget was rejected because there was a vote at the time. But because this budget and economic policy of the government came by way of statement, it will mean that the vote will not be taken. But those are some of the concerns the minority have raised. So ultimately, the comments will just bring an end. And the House
you've been in Parliament as a correspondent for some time now. After the debate on the economic policy of government, it's put to a vote, isn't it?
Yes, that is if the presentation itself came by way of motion. You only vote on motions.
Exactly,
well,
but
it's a statement.
So far as I remember, these budgets have come by motions.
Yes, but this particular budget did not come by motion. The finance minister, Dr. Kesela Tuforsin, came by statement. In fact, if you look at the other paper, it is a statement that came, and members of Parliament are commenting on the statement, which will mean that when the state commenting on the statement concludes, there will not be a vote. And that is why the minority had insisted to get a clear guideline on that, because they insist there are certain parts of the economic policy that the government will normally sneak into the statement that require approval of Parliament. But they haven't gotten their way with that. And so this time around, it came by a statement, and so there will not be a vote at the end of today.
Okay, I'm told that Roxanne wants to, make a point. So let's get back and hear from Roxanne Nelson Dafeamekpor, who is Majority Chief Whip of Parliament. Senior, you want to make a point?
My line dropped. The final point I want to make forcefully is that the allegation that the NDC knew of the judgment before coming to court is mostly inaccurate, and that is something that Afenyo raised sometime yesterday as part of his press conference. So it's proper that we correct it. We had no idea. In fact, the evidence that we have shows that the MPP rather knew the terms of the judgment before they came to court. And here is the evidence.
Share it with me.
By 9:56, the court has delivered its judgment and indicated that the full judgment of the court will be ready tomorrow, 28. By 10:13, the MPP had filed a notice of appeal and an application with affidavit properly sworn to and deposed to by 10:13, within 17 minutes. So they knew and they had prepared their notice of appeal.
Yeah, but Roxanne, that's where they say that they had actually picked intel because of how the NDC was behaving. So they decided to prepare and bring their appeal and everything based on what they had gathered from the NDC.
Winston, that is a blatant falsehood. If you don't know the terms of the judgment, if you have no idea, read the affidavit that they deposed to in 10 minutes, and type the affidavit out, and had it sworn to by a commissioner of oaths, all happening within 15 minutes. So these were processes that they had already prepared and they had in hand. And I must say that every smart practitioner would do that. But the allegation that we knew of the terms of the judgment is total falsehood.
But if you say that, no, but Roxanne, hold on a minute. If you say that every smart, practitioner would do that, then what's wrong if they did that? How do you say that they rather knew as if they've done something wrong, which you say is normal?
I have to say that if indeed you had prepared your notice of appeal and canvassed certain grounds, very interesting grounds, if without knowing the terms of the judgment, you could not have canvassed those grounds of appeal.
So if there's
any allegation that anybody had a hint of the judgment, it is rather the MPP.
Okay, so if every smart practitioner should do that, how does that smart practitioner get to do that thing which you say is wrong?
So the point is that is what lawyers do. That is what, when you lose a case, the smart thing to do is to anticipate that the case I had conducted was such that it may not favor me. Given the evidence led and recanted, it may not favor me. So you prepare. And the NDC, we were very sure of the case we had led, the evidence we led and cross-examine upon. We're very certain. Remember, who are the petitioners? We believe in the merits of our case. Winston, you have to see the evidence. You have to read the full judgment and read our address, the cross-examination and the answers that was elicited from even the Electoral Commission officers. There was no way MPP was going to prevail.
Okay. Thank you very, very much, Roxanne Nelson Dafeamekpor, for joining us this morning. Majority Chief Whip of the Parliament of the Republic of Ghana, joining us here on the Super Morning Show this morning. Indicate.
If you've watched the space over the period, you'd only send brotherly advice to Matthew Nyindam that he should return to the constituency as soon as possible to begin his campaign, because if the election happens, it's going to, really affect him. So he ought to be on the ground by now, organizing his voice and trying as much as possible to return to Parliament.
Exactly.